Hi everybody, this is Laws 13017, Civil Procedure. We're looking at the Week 5 materials dealing with pleadings and summary disposition. Tutorial problems 11 to 17. Okay. Right, so I've started the recording. I suppose I should check you can actually hear me.
Recording in progress.
Okay, you might need to mute your microphone there. Vivian, you've got, looks like you've got two things happening at once and that they're looping off each other. Yeah, okay, that's fine. All right, no worries. Okay, how are we going? How are we going with the unit at this point?
It's challenging.
It is. It is challenging, but you should learn a lot from it. And I think it'll get more manageable as you go forward, because it takes a bit of time to come to grips with it over, especially the first 5 weeks. Okay. All right. The assignment question's challenging as well. There's no doubt you're finding out.
It's not
Okay.
like family law. Family law was pretty full on too.
Was it? Okay. Family law. I actually wrote the family law rules together with a judge and a registrar. They were the old rules that have just been replaced. They were in force, I don't know, 15, whatever years. It was a long time ago. But yeah, no, family law, well, yeah, there's a lot in that as well. All right. Now, I've posted up the actual answers to these seminar problems. We will go through them just to make sure that you're following what's involved. So what I might do, just check the chat. Doing the assignment, yeah, the assignment is a challenge. Do you have any questions about that before we go any further? I've been answering questions about the assignment on and off all week and last week.
I've submitted mine. I couldn't take it anymore.
Okay, well, that doesn't sound promising. Wasn't that bad, was it?
It's the gift that keeps on giving, there's no doubt.
It's got a lot of twists and turns in it, though, hasn't it? It really
A
does.
bit like a mushroom cloud.
Yes, I agree.
Yeah, but you do learn a lot about the different processes in different courts and potentially tribunals to deal with that way as well. And you really have to look at your evidence, what's actually required, because not all of the information that your client provides is necessarily accurate or required. So you need to think about that as well. So I thought the 2000 words was included in the pre-formatted words. No. Pre-formatted words, I think I've said that quite a few times, but they're not counted. It's only, so you should have plenty of words to answer this up, because the actual pleading is pretty short. It's very short. When you actually get down to the very nuts and bolts of it, which is all you need. So remember, things are supposed to be concise, deal with a particular claim that you're making. You need a lot of words to do that. And some of the other things you've got to be careful around a substituted service and whether you meet the requirements for that, the information that the client's given you. So there's a few things to think about when you're going through it. Anyway, it's nearly over. Just the marking of it then. I did write the whole answer guide today, so sent that off to the market to triple check. Go from there. All right. Okay, but if you, as I say, if you have any questions, keep posting them up on the either on the Moodle forum or send me an email. Either way, I don't know. And if I can help you, I will. Okay, so problem 11. Problem 11 involved helix drilling equipment, so Blacktown mining. It's in the Brisbane Registry of the Supreme Court of Queensland, recovery of 400,000. Well, it's obviously too low, isn't it? So it shouldn't be in that court, it should be in the district court. But we'll ignore that issue for the time being. It says the statement of claim was filed in Brisbane and served in Warwick, Queensland. Okay, so that doesn't require any reliance on the Service and Execution Process Act because it's within Queensland. It was served on the 1st of April this year. Helix Drilling hasn't heard from the defendant. Okay. It's now August. How many days does the defendant get to put in a notice of an intention to defend? So Robert said 28. How do you calculate that time? Say 28 days, but how do you work that out?
According to the Acts Interpretation Act,
Okay, well, what does that tell?
it starts the day after.
That's right. It doesn't include the day of service, does it? But it does include the day of filing, if you like, of the notice of intention to defend. So you need to have a look at Section 38 of the Acts Interpretation Act about the reckoning of time. So if you're going to go for a default judgment at the earliest opportunity, you've got to work out when exactly that is. That's something relevant to your assignment as well. You're going for a default judgment. When is the earliest time you can actually go for it? Because that also affects the amount of interest. You've got to calculate all those figures. And when you get to interest, then you use that calculator that's on the website, which we'll come to a bit later. Makes it easier to do those calculations. Okay, so that's, you know how to calculate the time. All right. Okay, so in this particular problem we've got here, there's been no notice of intention to defend. So there's an entitlement to pursue a default judgment. Now, with this particular type of claim, what is the nature of it which makes a default judgment into the calculation? What's the features of it? It's a sum certain, isn't it? You know exactly what the figure is. So it's a liquidated amount, so you know what it is. So that makes it easy to calculate what the amount is. And then also the interest, because remember the interest is calculated as a percentage of the actual payment. All right, so it's a liquidated amount of debt, so it's fairly straightforward. So you can enter a final judgment. As a judge, who gives the judgment? Is it a judge? Is it a registrar? What sort of a judgment is it? Who gives it? No, it's a default judgment. But
It's an administrative decision by the registrar.
Yeah, that's right. So you choose it. So they're on the so it's a registrar that does it. So it's an administrative judgment. So they'll just be keen to make sure that the 28 days have elapsed and you've completed the forms correctly. And then if that's the case, then they'll stamp it and your judgment. All right. Okay, so interest. Let's think about interest. Where's the entitlement to interest up until the date of judgment? Where do you get that right from? Who says you're entitled to interest? It's not in the Uniform Civil Procedure books, it's something else. Anybody know?
Is it the Reserve Bank?
Well, that's the basis upon which it's calculated. The Reserve Bank plus 4%, and that changes twice a year. Potentially, they look at it and they add 4%. So that's how they get to the figure. Yeah. So Robert's come up there. Yeah. So it's a Civil Proceedings Act, Section 58. That's what I'm looking for. So that basically gives you an entitlement to interest. Okay. So in terms of that's the source of it. There's also a rule in relation to 2835. So it wasn't strictly correct to say there's no rules about interest. There are rules about interest, but your entitlement comes from the particular Civil Proceeding Act, 2011, Section 58. So if I put this up, so can you see that little table there? So if you go on the Supreme Court website, basically you can find this. And one of the things they have there is a calculator, which helps you calculate all of these amounts of interest. So the way in which you work it out would be when you were entitled to interest. So what? That's a good question. When are you entitled to interest? When does it start? Vivian, you're on mute. When does
The
it?
day after the debt becomes
On
due.
the 29th day.
Yeah, no, it's when the debt becomes due. That's the start period for calculation of
Okay.
interest.
The debt, okay.
Yeah, okay. So when you're looking down these effective dates, that's showing you when the actual interest rates potentially can change. And you can see there that it's round about the 1st of July in any given year and the 31st of December. But not every year changes. So you can see, for example, this period here, it was considered at 2 points when the Reserve Bank made decisions, but they didn't change the base cash rate. So the 4% was added onto it, but the interest rate didn't change. So what you'd have to do is, if, for example, you had an entitlement to interest which started on the 1st of the 1st, 2015, and say it ran for a couple of years, then you would have to multiply the amount of the debt, say it was 100,000, by 6 months at 6.5%, then another 6 months at 6%, another 6 months at 6%, etc. And that's a bit laborious. So what the court did essentially is create an interest rate calculator. And I hope that's what you use for your assignment, because it will calculate it exactly for you. It's dead easy to do, rather than you doing manually the calculator. You can't do it really, that's fine. But it's much easier just to use the interest rate calculator. So I've given you a link there to actually go off and have a look at that calculator, plug in the figures. And it will spit it out and tell you exactly what the interest is. And that's actually what the registrar would like to see, because if it's been put into that and it's produced that, the nice little neat printout, then that's something you can give to the registrar and they'll have confidence that you've actually calculated the interest rate. Okay. All right, so looking at our facts here, it's quite clear that Helix is entitled to proceed to get a default judgment. They can do that within 28 days after service of the claim. So if it was on the 1st of April, you then you ignore the 1st of April. So the 28 days is going to elapse when 30 days has September, April, July, November. So it's 30 days in April. You ignore the first day. So it's going to be on the 29th of April, isn't it? That would be the earliest opportunity you can go for a default judgment. Okay. All right. So what documents do you need for a default judgment? What are the documents? What do you want to have a go?
An affidavit of service.
Yes, that's right. An affidavit of service under Rule 282. What else?
Is it not for, we have the QCAT form number 6, version 4.
No, not the QTAC
No?
form, because we're looking at the Supreme Court here.
Oh, sorry.
Okay. So we're looking at the Supreme Court, so you need a different form. So which one do you need? Anybody know?
For a default judgment, is it 25?
Yeah, that's right. Request for a default judgment, form 25. An affidavit of service. What else? It's two
An
more.
affidavit of debt.
An affidavit of debt. That's absolutely crucial, because you want to actually say that the debt's still outstanding. There may have been part payments that have happened in the interim, compared with what's actually claimed in the claim. So an affidavit of debt. And one last thing.
Draft judgment.
Draft judgment, form 26. So they're the four things. So that's it. None of the parties actually need to attend court to do this. So it makes it a cheap way of proceeding. Ideally, that's what you want to pursue if you get the opportunity to be able to get a default judgment, because it's inexpensive. Right.
Stephen, may I just ask a question about the calculation of interest?
Yep.
in the draft judgment, there's a chance there to ask for interest up to judgment, right?
Yes, that's right.
Yep. Okay. Now I haven't been able to find anything in the text as to how the plaintiff can actually calculate that.
Well,
Because I don't know that. The problem is I don't know the day of the judgment.
well, you will, because you're the one who's actually applying for the judgment.
So that's the day of
So
judgment.
you will have worked out that
Yep.
in this case, it's the 29th of April. So you'll
Yep.
calculate interest up to the 29th of April.
All right, fine. Yeah, that's fine. I was trying to wrestle in my mind if the registrar takes 3 days to you know.
They're not that bad.
All right. Well, a day.
That's right. So
But
that's,
it's actually the date that I submit the draft judgment. Fair enough.
well, that's the only certain date that you know.
That's right. Yeah.
Yeah.
I
Sorry,
don't know.
we cut somebody off there. Who was that?
I don't think QCAT's quite as
As efficient. Perhaps not. So there may be some time delays with actually, I remember putting some things through. Yeah, you're quite right. They can take a little bit of time. The Supreme Court registrars aren't too bad though. But anyway, but if there is a delay, the only calculation you can put in was actually up to that. When you apply. Okay, that's that one. Problem 12. So it then says, assume a default judgment was entered on the 14th of April this year. Now, that is too early, isn't it? That's too early. It should have been the 29th. So that's a problem. In favour of Helix Drilling Equipment, it's come to the Managing Director's attention that the affidavit of service filed in the security application was not signed by the deponent on each page. It should have been. Blacktown Mining has just sent a letter advising its intention to challenge the default judgment and seek costs. Okay. Advise Helix in relation to the likelihood that the judgment will be set aside. So there's actually two problems with this judgment. Now, it is possible to get an abridgment of time to have a default judgment earlier, but reality is that's not going to happen. It's early, and I'm not sure why. There's no explanation of that. So that's one issue. The other issue is about this failure to actually sign on each page. And that's actually a requirement in Rule 432, swearing or affirming an affidavit. It says the person making an affidavit and the person taking the affidavit must sign each page of the affidavit. Okay. Now, remember that this is an administrative judgment given by the registrar. Personally, I don't think you would have got it before that. It's highly unlikely because it would have been quite. That's unrealistic. I only did that so that you would pick up that there's a problem with the timeline. But anyway, so what would happen is that there would be an application to set aside this default judgment under Rule 290, and they're highly likely to be successful given the two facts that we've found. So that's not just, so it could be set aside on that basis, but if they never entered a notice of intention to defend, there would be nothing stopping you going for a default judgment again after the 28 days had elapsed, okay, and making sure that you actually had your affidavit of service signed properly. Ultimately, what the defendant needs to do is, if they've got a defence, is file a notice of intention to defend, and they would proceed on with the actual proceeding. So anyway, we don't have enough facts about any of that. So the main issue with this was just to note that you need to be careful about the swearing of affidavits, and also be cognizant of the time periods. These sorts of things, no matter what side you're on. That. Problem 13, now assume that Blacktown Mining files a defence and a cross claim the 17th of April this year. All right. Claiming damages for interference to business caused by the delivery of the drilling rig, which it allegedly never contracted for. So this thing has arrived. It's now sitting in their yard and creating problem. Advise Background Mining whether it can obtain early judgment. Consider in particular what are the possible orders the Supreme Court of Queensland can make. What is the main risk posed by the application? All right, so we're not looking at default judgment anymore. We've gone past that. We're now looking at summary judgment. Okay, so this is actually a judgment decided by a judge. An application for summary judgment can be made by a plaintiff, and it can also be made by a defendant. Okay, now in our facts here, it's being made by the defendant. So you'd have a look at Rule 293, which sets out the requirements. So it says, a defendant may at any time after filing a notice of intention to defend apply to the court under this part for judgment against a plaintiff. Right? If the court is satisfied the plaintiff has no real prospect of succeeding on all or a part of the plaintiff's claim, and, so that's one requirement, and secondly, there is no need for a trial of the claim or part of the claim. So let's have a look at those two things. So no real prospect, so the plaintiff has no real prospect of succeeding on all or part of the plaintiff's claim. So when it says part, you can get summary judgment for part of a claim, excuse me, or it could be over the entire claim, just depending on what, if the plaintiff has no real prospect of succeeding. So you've got a very good defence. It has to be a very clear-cut defence. Or the plaintiff's case is so weak that they, for example, can't establish the cause, the elements of the cause of action. Then if they can't do that, then there's no real prospect of success and they'll fail. But the other requirement that you must do for the defendant is there's no need for a trial of the claim or part of the claim. So when would there be a need for a trial? What sort of situations can you imagine where you'd actually need a trial?
If the evidence needs that the plaintiff presents needs to be tested, there would be a trial.
That's right. So, for example, if it's relying on oral testimony, because remember these summary judgment applications are essentially done on papers and documents. So, if you wanted to test the witnesses, then you need a trial to do that. So that's not something that you can do in a summary judgment. It's not designed for that. The trial is the thing that resolves those sorts of questions. So somebody fronts up saying they want to call witnesses to prove their case, then as a plaintiff, if the plaintiff says, well, I don't want to call witnesses, or if the defendant wants to challenge statements that a person has written in an affidavit, then they want to call the person who wrote the affidavit to challenge their evidence and examine them. So in those sorts of situations, it's not appropriate. There is a need for a trial to resolve those sorts of things. So these summary judgment things have to be very clear-cut types of situations on the papers. So it'd have to be a very simple factual dispute in relation to this contract. So plaintiff would have to have a reasonable cause of action. If they had a reasonable cause of action, then the summary judgment's going to be very difficult for the defendant because the plaintiff has a real prospect of succeeding in that sort of situation. So the defendant, unless they've got a really solid defence, like, expiry of a limitation period or something like that, then...
I mean, sorry, didn't mean to interrupt, but I mean, just in those facts, I realise a lot more has to be gathered, but accepting delivery of presumably a very large rig into their yard is evidence of something.
Well, yeah, it is. Well, maybe they didn't accept delivery. Maybe it just got dumped there. I don't know.
They
We don't
just
know.
parked it there overnight.
It's got parked. We don't know. But the main thing about the question is to look at the requirements of Bill 293. And, you know, summary judgment's a good way to go if you've got a case that fits this narrow set of circumstances. Okay. Okay, so Robert said there's no allegation, there's no contract, so it indicates nothing in writing. Yeah, I mean, it could be an oral contract, but I think you get the gist of what that is about. Now, 14. Now, okay, can any of the following civil legal proceedings be commenced within the jurisdiction of the magistrate's court? If not, why not? Claim for 175,000 for a debt owing to a bank. Okay, so what's the jurisdictional limit of the magistrate's court?
150.
Yeah, so you need to look at the Magistrates Court Act 1921, Section 4. So it's 150. This is beyond that, so it's in the district court. Okay, so it's in the wrong court. If you actually had this heard in the Magistrates Court, the court could only order up to 150,000. So, you know, really it should be transferred to the district court. Then the next one, a claim for 5,000 being arrears of child maintenance. Okay, so where does child maintenance fall within the general jurisdictions that exist in Australia?
The family court.
The family court. Okay. So, well, if the lower level of the family court, if I can put that now, it's actually in the Federal Circuit Court of Australia. Will deal with this. And you can find that under the Child Support Assessment Act 1989, Section 99. The family court itself deals with much higher level disputes, but this circuit court will deal with that. Yeah, so if you ever see anything that involves federal jurisdiction, always have a look around for the statutes that are relevant for that particular area, whether in this case family law, but it could be whatever area, or some section somewhere, government, which court needs to look at it. The third one, claim for family provision against the estate. Okay, now this is a bit more tricky. The estate of a deceased parent by an adult child. So this is not family law, this is something else. What area of law is this?
It's succession.
It's succession law, that's right. So in this case, there's an act, there's a succession act which tells you that this has to be dealt with by the Supreme Court. Now you might wonder, well, why is this sort of matter, why does it have to go to the Supreme Court? We haven't mentioned any amount at all. So it's not based on the value or the amount involved. Why is it going to the Supreme Court? Logically, why do you think that's the case?
Is it because it would involve land?
No, it's complexity. I think it just comes purely down to complexity that the states, typically they're going to involve trusts, probably discretionary trusts, and it's just generally a complex area. And I think that's the reason for it. It certainly could involve land and other property, but I think it's more potential complexity of that area. That's why the legislation is there. Even this next one, D, a claim for declaration as to entitlement under trust where the monetary value of the claim is 50,000. Again, this is a situation where there's the Trusts Act 1973 is making this a matter that has to go to the Supreme Court. And I think it's all about complexity. So I think the moral from all these examples is that there are statutory limits for the particular levels of the courts, but you always have to bear in mind the nature of the claim whether it's related to a federal matter or a state matter. If it's federal, you've got to check the federal legislation as to where it goes. If it's a state matter, then you have to think, well, not all state-based matters follow these rules about the jurisdictional limits. There are exceptions. So you have a couple of examples there, but there are many others. So whenever you're dealing with something, don't just automatically assume, it's, 149,000, it must go to the district court. Now that's your general rule of thumb, but you need to look a little bit deeper so you don't get caught out by other legislation. Okay. Problem 15. What do you understand by the expression no real prospects of success when used in the context of a claim, statement, claim, defence? All right, so this is a bit of an ethical question. So what's all this about? No real prospects of success. Any suggestions? Oh, somebody's going to make a suggestion.
Is it to do with whether a solicitor should take something like that on if they don't think it has, any value or any real chance of success?
That's right, but what's underpinning that? You've got a duty to who as a solicitor? Who do you owe your duties to? To the courts.
client,
Now, Robert said
to
to the court. Yeah, to the courts, and it's not just to the courts, to the client, to the courts and the client. Which one has paramount? What's the priority amongst those two? The court has the highest priority. Okay. So you do see in various rules in the different jurisdictions an emphasis on not wasting the time of the court. And also, you should be advising your client, if they don't have any real prospects of success, you should be telling them. So you shouldn't be taking on litigation matters if there is no real prospects of success, because it's unethical. And the risk that you run is that the court could actually order costs not only against your client, but you personally. Because remember, costs are going to be incurred. As soon as you sue somebody, you're incurring costs. So if that lawsuit had no reasonable prospects of success, the client's incurring costs, the defendant is incurring costs, and you're starting to use up the resources of the court as well. That's so
It's a fairly, sorry, I think it could be a fairly difficult judgment call.
it could be. I mean,
given the uncertainty of, no one can say with 100% certainty what the court is the judgment that's going to be handed down.
well, that's right. So it all depends on the question of law, and there may be conflicting authorities. So if that's the case, it wouldn't be a situation of falling into this no real prospects of success, because there would be a prospect of success if there's authorities you can rely on to argue your side of the case. You mightn't have, you mightn't be in the strongest position, but you do have a position. We're looking at something where there's really no position that you
You've got
can.
absolutely no evidence to support your claim whatsoever, or the evidence that you have is really just, it's not worth the paper that it's written on, then you do need to advise your client no.
Absolutely. That's not a case you should be taking on. Remember, as a solicitor, you don't have to actually take on cases. You're not subject to the cab rank rule of barristers. But so there's a fine line. You don't see many of these types of orders being made, right? But there are provisions in the rules for lawyers to delay or neglect in relation to costs, but real prospects of success could fall within that as well as a form of misconduct. But actually, if you look at Rule 690, it does actually show you the other things. So if if you've got lengthy periods of delay, if you're so appallingly slow in how you're running things, and that delay occasions costs or causes other sorts of problems, it could be death of witnesses, loss of evidence, those sorts of situations, then you could be liable to pay costs. Misconduct could arise in the situation we're looking at now if there's no real prospects of success, or plain negligence. If you're negligent in the way in which you're advising your client, then apart from the risk of being sued for negligence by the client, you also have these orders for costs that can be made by the court under Rule 690. So, yeah, I suppose the moral out of all of this, and there's a few, always evaluate your client's case. And of course, what I mean by that is whether there is any chance under the law in terms of achieving the remedy or the defence that they're trying to make, and whether also the question of evidence, is there evidence to support that and underpin it? If neither of those things exist, you've got to tell your client, well, look, you don't have any prospects of success, you're wasting money, and you don't take on that case. And you avoid delay, and you should also avoid negligence, which is sort of, yes, they're the main things. But I think the part payment of costs, if you're negligent, is going to be the least of your worries. So in some of the other jurisdictions, not Queensland so much, there's so the ACT, New South Wales, and I think South Australia, there's New South Wales just came in as well. That this requirement applies to claims or defences for actions seeking damages. Lawyers have to actually produce a certificate that the claim or defence has reasonable prospects of success. I think the federal court does that as well, actually. Yeah, it's all applies to the federal court. Yeah. The lawyers represent an applicant who's commencing migration litigation that certify reasonable grounds for believing the migration litigation has reasonable prospects of success. So we don't have to produce certificates in Queensland, but in other jurisdictions you do. I think the reason for that is to bring this to the mind, to the attention of the lawyer, to remind them they've got to do this because they've got to produce a certificate. So you've got to fill that in, you can sign it, you're obviously going to think about the issue. Whereas in Queensland, you're not required to do that, but you are, in terms of a formal certificate, but you are required to do that. Okay. 16. John Brown, the plaintiff in a personal injuries action in which the claim is quantified at 100,000, seeks your advice on whether or not he can and should apply for summary judgment on his claim. What would your advice be? Okay, well, that doesn't really give us much in the way of facts other than it's a personal injuries claim. It's actually been, so that the amount is 100,000. That's been calculated. So what do you think about this situation? So this is not a summary judgment for the defendant, is it? This is a summary judgment for a plaintiff. So which rule do we look at for that? It's 292, that's right. Now, if you look at the wording of 292, it's fairly similar to the previous rule for defendants. So it says a plaintiff may at any time after the defendant files a notice of intention to defend, apply to the court for either this part for judgment against the defendant if the court is satisfied that the defendant has no real prospect of successfully defending all or part of the plaintiff's claim. Okay, so it comes down to an assessment of prospects. And the other same issue as before, there is no need for a trial or of the claim or part of it. And if that's the case, then they can give judgment. So the language is very similar, pretty much identical, for the plaintiff situation as it was for the defendant. So it is possible to apply for that under Rule 292, and it's possible for a registrar. Well, it's not really, it's interesting, there's a 2833, I don't have that in front of me, but says a registrar may grant a judgment, but really normally with summary judgments it would go before a court. 2833, so check that because that sounds a bit odd. It'll be usually a court would make that determination. Okay. What have we got? Problem 17. Now this is really important. Problem 17. Not the other ones weren't, but 17 is really important for a few reasons. This is the issue of discontinuing. Now you might naturally think if you're suing somebody or several people and you want to discontinue against one of them, you would just do that and they would drop out. A big problem is costs. So, and this is what's coming out of this question. So if we look at the actual question, it says, Sky wishes to discontinue her action in the Supreme Court and then consider these situations. Sky commenced proceedings against Julian in the Supreme Court of Queensland seeking damages to personal injuries. The matter has been allocated a trial date 1 month away. So this has really progressed right through all those expensive stages of the litigation. You know, where all the costs are jumping up. There's the, you know, the expensive parts are where you get the expert reports, where you have your solicitors draft and settle pleadings, any discovery that may be involved. You're then coming up to the expense of the trial. So, you know, there'll be trial preparation occurring because it's coming up to the trial date. So there's been a lot of expense happening. So if Sky wants to discontinue, what's she got to do? There's two ways she can do it. So what would she do? She can ask the court, okay, for leave, or she can ask Julian for permission. So that's in Rule 304. Now, if Julian says yes, he's entitled to costs up to the date of which the notice of discontinuance was filed. So he's going to get his costs. But Julian could also put terms. So it's almost like a settlement in effect. So Julian could say what the amount of costs are and the time allowed for payment of those things. And when we talk about costs, when we ultimately get to the costs part of the unit, you'll find that generally if a plaintiff wins, they're not going to get indemnity costs. They're not going to get 100% of the costs that it's actually cost them to run the litigation. They're going to get a much lower figure, probably around about 60% of the actual expenditure that they've made. The reason for that is that there's a scale of costs and there's the production, usually production of a bill of costs by cost assessors, and then there's arguments about whether the claims that are made for expenditures were valid or not and the amount that was charged for them. So the end result of all of that will be that they only recover, say, about 60% of what the expenditure was. So in Julian's case, Julian would have spent all this money defending himself, and he wanted to make sure he got that back because this plaintiff's discontinuing, they're giving up. Why should Julian only get a 60% return? So Julian may not say yes. So it then comes down to an application to the court. And the court basically can make whatever order they think fit. The court could impose conditions as well. But basically, Sky is not in a very good position if they're seeking to discontinue. They're going to have to pay costs and there'll be an argument over how much those costs are going to be. Right. So that's that. Then it says, Sky and Dean, who live in Noosa, commenced proceedings in the Supreme Court of Queensland against David, claiming damages for breach of contract of sale. The contract involved the sale of a combi there. The matter has been allocated a trial date 1 month ago, 1 month away, so again, very late. David does not consent to any discontinuance of the proceedings by Sky. So here we've got a situation of two plaintiffs. Sky wants to exit, and David, who's the defendant, doesn't consent to the discontinuance by Sky. Okay. Even though the other plaintiff, Dean, is still in the litigation. So there's no issue about Dean. It's still there as a plaintiff. It's only Sky who wants to leave and the defendant's not consenting. So the only option for Sky is for the court to give leave, and the court could impose conditions. So that's the answer to that. And with the applicant rule 307, that actually talks about the costs involved, and it says a party who discontinues or withdraws is liable to pay the costs of the party who discontinues or withdrawal relates up to the discontinuous withdrawal, and the costs of another party or parties caused by the discontinuance or withdrawal. So in theory, Sky could actually be up for any cost that the remaining plaintiff has to pay for as a result of Sky's discontinuance. So
Would
it's
that even be if they've still got to defend against the other plaintiff? Because they're still going to need the work that they had done.
Okay, two things there. The defendant, given they're so close to trial, they would have done a lot of preparation in terms of the defence, all of their evidence, as it applied to these two plaintiffs. So the extent to which some of that was wasted expenditure in relation to Sky, that would have to be considered. But you can say costs effectively were thrown away that were unnecessary. So Sky would have to compensate. If you look at the situation of the other plaintiff, so that's D. So they're remaining. So any costs that they may have incurred because Sky was in there as well, which is now being thrown away, Sky will have to compensate them as well. Because these different plaintiffs may be in different, slightly different positions. They might have separate representation. Some representation. So you need to bear those sorts of things in mind. Don't assume that because there's multiple plaintiffs, they all have the same counsel, same solicitor's firms.
What about compensation, monetary costs aside, for the inconvenience that it's caused for the defendant to be prepared for all of this?
Really, no, it's really the costs that you can prove in preparing the costs. So if there's an argument over what these costs are, then they may need to prepare a bill to work out what exactly it is. No. It's the same way, it's the same sort of situation if you're accused of a criminal offence. You're put in prison pending being resolved and ultimately released and not proceeding. You don't really get compensated for the time that you're in jail. Separate proceeding for false imprisonment. Yeah, not all things are compensated. So it's only the costs that you can identify. So it's not mental anguish, solicitors' costs that we're talking about, barristers' costs, costs of expert witnesses, reports, things like that. You don't get compensations. Some you think you should be entitled to it. Think about it, given the inconvenience, but you just don't get that. All right. What's the third? Another one. Sky and Dean commenced proceedings in the Supreme Court of Queensland claiming damages against Sam for the conversion of certain property, respecting which they were uncertain at the time of the commencement proceedings as to which of them had title. So here's here's confusion between Sky and Dean. They're not sure who owns the property. They claimed in the alternative damages for their loss, so they were really aiming for the court to resolve that question. Sam has just delivered the defence, and it's now become clear in the meantime that Dean has in fact the title to the goods and that Sky wishes to discontinue. Okay, so in this situation, think about it.
It's probably best if Dean discontinues as well in those circumstances, isn't it?
Well, maybe, but I think from Sky's perspective, Dean's not going to object to her disappearing. And I'm not sure the Sam, the defendant's going to object either, because basically she has no interest in the litigation. So she can discontinue with the consent of both of the parties, or she can seek permission of the court. But again, she's going to have to pay the costs thrown away because of the discontinuance. Then, so if we have a look at the position of Dean, so we now know that he has title to the goods. So Sam's in a bit of a awkward position. What's his defence if Dean's actually has title? Sam's converted. And Sam's in a pretty precarious position as well. He might want to try and settle.
This is one of those times you need mediation.
Yeah, this is a good example where you want to mediate a solution rather than trying to litigate something like that. Well, in fact, look, all cases you should look at mediation or some sort of solution before you get to the stage of trial, because you're spending a lot of money. $30 title search. All right. So that's that. And next week, what we're looking at is disclosure. So that's another area which is really expensive. That's a really expensive part of litigation. If it's a litigation that has any collection of documents associated with it, this is where it becomes very expensive. Because the solicitor has to look at those documents and make decisions about whether they're relevant to the pleadings, has to make decisions about whether there's any privilege associated with them, and whether they need to be disclosed. That's a really expensive part of the litigation. If you want to save costs, you want to try and settle it before you get to disclosure. All right. Any questions about any of the stuff we've looked at in those tutorial blocks? You're happy with that?
Stephen, may I ask a question about something else? I was just looking at the specification for the next assessment that specifies a word count limit of 250, 2,500 words. And my question is, what does that include? And my reason for asking this is that in some recent units, I've found what I thought was a fairly novel requirement, which I was happy to comply with, that included citations and footnotes. And I mean no more than Diedrich and the Queen, CLR, etc., etc. So my question is that kind of citation in the footnote included in the 2,500 or it's not?
How do we be careful?
Thank you.
Mind you, I'm not expecting you to have a bigger essay in footnotes than like in the actual text.
Yeah, I'm not talking about any. I don't mean any substantial comment.
No, that's not.
I could understand why that would be kind.
I don't count the footnotes.
Thank you.
Mind you, I don't want font size of microphone either. So yeah, no, look, that's fine.
Stephen,
Yes.
with the second assessment, do you require bibliography or what is all right?
I don't think so that won't be counted either.
Okay, no, thanks.
But I mean, it is challenging as well because the word count is fairly small. It's always harder to write something in less space than it is to have a lot of space. And that's the challenge.
Usually you've got to write it and then take a hatchet to it.
You do, but that's part of the process. I did actually find a really good website. I'll show it to you. So you can see what I can find. Yeah. This is a site. So this is a site that can help you with arguments and you can write things. It's really good. So I use this with my PhD students. So have a look at that site if you get a chance. It gives you some guidance on types of wording and structures of sentences. So it's really worth looking at. It's an English site, but hold that against it. I think you'll find it useful. All right. Any other questions, queries, comments?
Yeah, a couple of tutorials ago, you mentioned a couple of books that list out your causes of actions.
Oh,
I didn't get those.
So there was this one here. Okay, so that's Pleading Precedents 6th edition by Size et al. It's a law book. But look, you don't want to buy these books because essentially they just list different sorts of ways of setting out different types of actions. But the one you've got for your assignment is pretty easy. It's not hard to do. Now, these are only guides. Okay, they're not, you don't actually have to have them dead on what they say. They're only sort of a guide. The one you've got in terms of your assignment, you wouldn't need a book like this. And there's other books like, there was Bull and Bleak, but I'm not sure the library would have that. It's, there's other sorts of books like this little one here on by Rose, and it's entitled Pleadings Without Tears in Australia, so it sort of helps you look at how you plead things. Any of these sorts of books you borrow from the library, but now the pleading you've got to do is not that hard, so you shouldn't have too much problem with it. The challenge for you is to exclude the irrelevant stuff. It's like any sort of situation. There are relevant facts, there are irrelevant facts, and there are missing facts. Okay. So you've primarily got relevant and irrelevant ones. There's not so much in like missing ones. But the irrelevant ones, I don't want to see those coming through in the pleadings. They're not needed. So you have to look at all of the documents you've got, for example, are they relevant? So the way to approach it is to look at your cause of action and to work out what are the key things and key dates. So if it's a breach of contract, when was the contract formed? What were the terms of the contract? What was the date on which payment had to be made? Was it made? So you basically got offer acceptance. Did that happen? Then you've got the consideration element to it. Did that happen? And then was there a breach? In other words, what was the date on which the payment was due but not made? It's pretty straightforward, which is why it's designed, because it's you're learning how to do this stuff, so we're keeping it as straightforward as possible. That's the
Well,
sort
mine's already gone in, and there may be the odd thing in there that I've just slipped in just in case.
yeah, well, you know,
Because you never know, something might be showing that at least they did have control of the vehicle and did do something to it.
I'm looking for I'm looking for the key things. Maybe it's a sort of minimalist world, but it's just sort of what are the key things that you need to do to do your client. Now, if you're worried about that and you want to look at it again, maybe you don't know, it's so sick of it, you don't want to ever look at it again, but if you do, and if you've submitted it, I can send it back to you as a draft if you want. But you can let me know.
The problem is that it took so long to scan it in
Okay.
into one document. I wouldn't be looking forward to that again.
No, well, that's okay. With those documents, it's interesting, isn't it? Because some of them, say QCAT, for example, has PDF type screens you can fill in, and then you need a PDF editor to easily edit them. And, I don't know, does the university let you have access to Acrobat Professional? Or?
So I had to print it all out, then scan it all back in, and I've got one with an automatic document feeder, but I had to sort of baby it through.
Yeah.
And it was like, I think I had about 52 pages all up.
Yeah, it takes time.
And I wouldn't look forward to doing that again, to take one page out.
And same with if you're looking at the magistrate's court documents, you're seeing those in, well, there's Word format. Do they have a PDF as well? Well, the Word format's more manageable if you've got Word. Then you can convert that, you can save that as a PDF. So if you wanted to put signatures and things onto it, you could take a picture of, say, with your phone of a signature, save it as a picture, and insert that into your Word document, and then save all of that as a PDF. So
I've got like an Acrobat Professional thing, and with those forms, what I'm trying to do is normally with a PDF, I will try and rearrange the pages under the editing functions, and I would just cull the earlier parts of the court documents that are just the explanation, but it comes up with some message that this is XPS protected. You cannot do that. It's very difficult. It's essentially, it'll have to just be printed, and then the pages that are needed scanned and then reordered.
You're doing what you would have to do in practice.
Yes, I've had to do it in practice.
That's the scary part of it, isn't it? That's actually what you have to do.
You're trying to drive us to distraction so that we know exactly what we're getting into.
Well, I'm just giving you, what is it? Authentic assessment. It's got all the elements of it. It's got clients who are telling you things that are hard to follow, got inconsistent things with documents, and then you've got which jurisdiction do you send it through, and there might be more than one choice, pros and cons. So, yeah, it's got all the elements, hasn't it? Anyway, it's a good exercise because it gets you to actually, explore what sort of, this is basic sort of work you would do in practice. And if you went into a litigation section, it's some pretty basic sorts of things that debt collection.
I definitely think that it would be much better once you've done a few of them.
Oh, absolutely.
Because the first one is a nightmare.
Yeah, you can say that about anything, isn't it? Of course, once you get it, and if your firm's got precedent set up, then you haven't got all these formatting issues to have to deal with, because it'll all run a whole lot smoother. But you've got to learn. Something. All right. Well, I hope I haven't killed everybody with this assignment. I'm even worried how everybody's telling me that. All right. Well, the next one's not as challenging with all of these electronic things and formatting and what have you have to get used to.
My scanner jammed at page 27, and then so I had to start again. So I'm not looking forward to getting it back and taking a page out.
Well, you let me know if you want to get it back. Just send me an email if you want to do that. Okay. All right. No other questions?
Can I send you an email saying ignore page such and such?
Maybe that's the way to do it. Well, how about you do that? Why don't you do that? You can tell me that, and I'll send that off to the marker. Because I've written an answer guide, but I'm not actually marking it. So we've got a practitioner marking it. But I've done the guide. And then I'm going to sit down and go through a few sample student answers and see how it all works out.
I wouldn't be the first solicitor, though, to baffle someone with disclosure, would I?
All right. Okay.
I'm getting more and more anxious.
But it's interesting, isn't it, how a relatively simple issue has so many, simple problem has so many issues with it.
You better go.
I'm going to have to send everybody off
Good luck,
to counselling
everyone.
at this rate. All right, time to go. The exhilarating levels are going through the roof. I'll see you next week.